My name is Mike Madigan. I'm an attorney from Columbus, Ohio. I focus my practice primarily on construction law, dealing with construction disputes, looking at the fine print of the contract that nobody wants to, but unfortunately it seems like more and more times we're having to these days. So what we wanted to talk about is some key contract terms to look for when you're looking at a contract and you're weighing the option of whether or not you want to go ahead with this project, and just some things to keep in mind. We've got a relatively small group here. I've got 45 minutes. If you have questions, feel free to ask them, or I'll stick around here afterwards and we can go over some of the specific instances. But I want to make myself as available as I can for everybody here. It used to be one of the key. Everybody used the AIA subcontract, and it used to be everyone was using the 1997 edition, and that was endorsed by the American Subcontractors Association and then the Association of Specialty Contractors, but not the American General Contractors. At the time, that 1997 edition was probably the most favorable to a sub. If you were a subcontractor and you were working under an AIA document, you were probably better than most people with other form contracts. That was a good place to be in that area. AIA has since updated their contracts starting in 2007. The 2007 version is still pretty good. There's a lot of nasty subcontractors out there that you can be tied up with. Again, the AIA is you're going to be better than most, but it's less favorable to subs these days. If you wanted to kind of take a snapshot, the 1997 version was probably better. The 2007 version is probably not as much. The AGC contracts, there was kind of a change. In the past, you had AIA, and then you had the AGC contracts. Well, now, starting in 2007, you still have the AIA subcontracts, but now they've got this consensus docs, which is really a lot of these AGC subcontracts. So you've got AIA and consensus docs probably being the two competitors in terms of form contracts that are out there today, and that started back in 2007. And prior to 2007, AGC had their versions here: the 650, which had the pay when paid, the 655, the pay if paid. We'll get into the specifics of what that means. But now all that has changed. Starting in 2007, it's really you're working under the consensus. The AGC has now morphed itself into the consensus stock 750, which is a pay when paid term. So kind of going back to what I talked about earlier, consensus docs is probably is better than the AIA in terms of if you're a subcontractor. AIA is still probably pretty good, and then if you get into one of these these form subcontracts from a large general contractor or something like that, that's probably the least favorable. So kind of a little background on how the AIA and the consensus docs evolved. We'll get into the specifics of the contractual clauses that you want to keep in mind. First one is the payment terms. There's three really basic payment terms. There's the pay if paid, which is the least favorable to a subcontractor. Somebody I presume is in your guys' shoe that's not in contract with the owner. There's the pay when paid, which basically says, a pay if paid basically says, look, if the owner doesn't pay the general contractor for whatever reasons, the general contractor doesn't have to pay you. So if the owner goes goes bankrupt, whatever happens, the risk that the owner is not going to pay the general contractor is on the subcontractor. A pay when paid is different. Pay when paid basically means that the general contractor is still obligated to pay his subcontractor despite what the owner does or doesn't do. He just has to pay it within a reasonable period of time. It's not necessarily fixed, but the courts are going to construe that as something reasonable. What's reasonable? Probably 90 days, is definitely going to be reasonable, 60 days maybe. But that's the key distinction there is from somebody that's working downstream from the owner. You want to avoid a pay if paid if you can. It's hard to do it in this climate because your larger contractors have that. But you want to look for a pay when paid payment terms. Like I said, the AIA and the consensus docs have that. The other payment term is kind of an obvious one. It's a fixed payment term. Instead of this reasonable period of time, it says we're going to pay you no matter what within 30 days, 60 days, despite what the owner may do upstairs or whether or not he pays. As I indicated, the pay if paid is the harshest payment term. If for whatever reason the owner goes under, owner goes bankrupt, everybody downstream that has a pay if paid term is going to be on the hook for their costs. There's an attorney in Columbus that his selling point is I don't get paid if you don't get paid, and it's kind of the same idea with the pay if paid. If the general contractor doesn't get paid, no matter what happens, if it's a properly drafted pay if paid clause, you're going to have trouble getting around that, presuming it's not something that your specific state law prohibits. How to spot a pay if paid clause? They'll use the term condition precedent, and that'll basically say, look, our obligation to pay the subcontractor is a condition precedent upon us receiving payment from the owner. So you can see that when you look at the fine print of a contract, and this is one of a national contract, you can look at the progress payment terms, and you can see the term condition precedent. If you see that somewhere in that big lengthy paragraph, it's probably a real good bet that you're dealing with a pay if paid clause. Well, I guess that's what it's very hard to read this and understand what's actually going on, right? But I guess the point I'm making here is when you see these big monster payment terms, and you see contingent precedent, it's going to be a real good bet that you're dealing with a pay if paid clause. A legal standpoint with respect to pay if paid clauses, because they're very harsh, and judges and the legal community sees how harsh they can be. So they basically require them to be drafted in a proper way. So what that means is if a judge can look at it and say, you know what, I'm going to give the subcontractors the benefit of the doubt here, he's going to find a way to do that. And that's kind of the way that the law is drafted there. So for a pay if paid clause to be enforceable, it's got to be clear and unambiguous. And a lot of times the lawyers will fight over that. Is it really that clear and unambiguous? Because there's we start going into all that mumbo jumbo of the contract to find ways to make it unclear, unambiguous, to try to get around the pay if paid clause. But if you're in that position, you're going to be spending a lot of legal money making that fight. But all is not lost if you're dealing with a pay if paid clause and someone didn't draft it right. As I alluded to earlier, the future of pay if paid, currently it's unenforceable in certain states, Wisconsin, South Carolina, Delaware. And you've got this conflict between a pay if paid and in the mechanics lien. What good's a mechanics lien if there's a pay if paid clause? And there's a recent case that basically said, well, look, we've got a statute that says you can't waive your lien rights. Yet on the other hand, you've got a pay if paid clause that basically does the same thing. So we're going to find the pay if paid clause is unenforceable. That's a decision that came out. I've got noted here. So you kind of see cases out there that try to nibble around that strict, oftentimes harsh ruling of a pay if paid clause. But again, if you're in this situation, you're going to be spending a lot of money to fight these fights. As I indicated, the kinder, gentler payment term is the pay when paid. It basically says, look, the general contractor in this case is still going to have an obligation to pay you even if the owner doesn't make a payment. The key there is within a reasonable period of time. Here's an example of a pay when paid clause. If the architect does not issue a certificate for payment or the contractor does not receive payment for any cause which is not the fault of the subcontractor, the contractor shall pay the subcontractor on demand. There's no condition precedent language in there or anything like that. Some practical pointers when you're looking at contracts. You want to avoid the pay if paid clause. It's very hard to do though in this market, but there's a risk factor that should go up if you're dealing with a pay if paid clause and you don't know the whereabouts of an owner, you don't know the financial stability of the owner. You're really risking a lot going forward. Try to insert pay when paid language. You can use the AIA 401 or the Consensus Doc 750. One of the negotiating ploys is, I shouldn't say ploy, but if you're dealing with a contractor, general contractor that's a part of AGC or part of one of these associations that's endorsed Consensus Docs, you can say, look, this is an industry standard. Your association endorses it. I'm not asking for something that's out in left field. My price is good. My price is reflected on a pay when paid language rather than a pay if paid. The other thing you can do is modify the pay if paid language. You can add some terms to it where you basically are saying, look, I'll go along with this pay if paid so long as it's not a result of the owner's failure to pay. Is caused by reasons not attributable to the subcontractor. So if the owner's not paying for something that's not my fault, the pay if paid clause isn't going to apply. If the owner's not paying because it's something I did wrong, I'm okay with that. But if the owner's not paying because he's bankrupt, or if the owner's not paying because there's another subcontractor that didn't do what he was supposed to do, that pay if paid clause isn't going to apply to me because I'm basically just limiting it to the things that I do wrong on this project. So in this case, you're still in the hunt if the owner, goes bankrupt, or if there's if there's another problem sub, or the general contractor doesn't do what he's supposed to do, and you're just wrapped up in this big, project where nobody's getting paid because the owner didn't get what he wanted. In this case, you can still go back to the general and say, look, this wasn't my fault. You still owe me. I'm sorry about your luck on the other contracts. Another option when you're confident the owner has the resources to eventually pay, and in this case it may be like a public project where you're a sub underneath the general contractor, and in those situations the idea of a public authority going bankrupt is, at least at one point in time when I wrote this, was pretty extreme. It may not be as extreme today, but in that case, maybe you can take the risk to say, look, if the owner goes bankrupt, if the owner can't pay, I'll take the risk of that. But if there's any other reasons why I'm not getting paid, your pay if paid clause isn't going to apply to me. Just try. This is probably the least favorable, but it's better than having a straight pay if paid clause that you're dealing with. So you're just trying to nibble away at this. And in this situation, you're taking the risk where if the owner doesn't pay. But in a lot of situations, if you're working for an airport or something like that, maybe that risk isn't as big, but you're still preserving your ability to get paid if the project goes south and the owner doesn't pay because somebody else wasn't doing their work. It's kind of a negotiation tactic. If all else fails, I saw this article here where a group of workers ended up holding hostage people until they got paid. No damage for delay provisions. Kind of the next point we want to talk about is.
In a lot of projects, if you're the subcontractor on a large project that might go 3 years, and you have a small part of it, and you're going to be done in the first 6 months. Well, you wouldn't want your retainage to be held out for the 3 years that they're done. What type of language do you put in there so that you get to bill your full amount prior to the end of their 3 years when they're going to bill their retainage?
You can put in there specific line item retainage that your final payment is going to be based on the acceptance of your work. That's going to be, candidly, that'll be hard. That's a hard thing to get in your situation. But it is something that you can insert into the contract saying, look, I expect final payment. on that last slide where I was talking about final payment's not going to be contingent on the owner, paying you. Final payment's going to be on, when we complete our work. You add some language like that within, maybe 60 days after when we submit our last pay application. But that's a hard position to be in, because a lot of times, you're kind of at the mercy of what the general contractor is doing.
Just a concept on the last one is that if the general contractor has a relationship with the owner, and he's supposed to be making money off your services, so if he's moving you in the front seat with him and making you take the same risk, it's good up front to start asking questions. Well, tell me about this owner, and what is your terms to get paid? And you're making money off my services. It's supposed to be your risk. So you're adding 20, 30, 40, 50% on top of my services, and yet you're not willing to accept the risk to get me paid. Then you've got to tell me all about your client and what the situation is. You're forcing me to accept the same risk terms.
Right, and the consensus docs has language that talks about that. Number one, they're supposed to provide financial information about the owner, and in the general contractor owner's contract, if they don't do that, the general contractor could stop. Back to your point about trying to set something up to be able to get retainage, in the consensus docs contract between the owner and the contractor, it says there's going to be no more retainage after 50%. And the owner, and the owner's not obligated. The owner can do line item retainage release. So AIA doesn't have those terms. It's just kind of blank. It's left for people to put together. But I guess that's kind of, if you're dealing with the consensus docs family, you've got that benefit to be able to go to rely upon. And then, back to your point, be able to get the financial information. In this market, at least in Ohio, that's really important to be able to understand, what's the financial wherewithal with these owners. And if you don't get it, then you've got the ability to be able to stop. No damage for delay provisions. Basically, what a provision like that will look like is something like this, where the contractor acknowledges it may be subject to interference, disruption, hindrance, or delay. The sole remedy is going to be an extension of contract time. All you're going to get is, based on what this contractual term says, all you get is time. You don't get any money. That's it. Now, we all know that, when you're having your rigs out there, that's costing you money, and that doesn't work from a practical standpoint. In Ohio, provisions like these are unenforceable. So no matter what an owner puts in there, if an owner delays a contractor or subcontractor, the subcontractor could go back and get his delay costs. And you'll probably have similar statutes elsewhere. But if you're reading this and you don't have the benefit of that statute, 4011 or 4011-1362, then you want to be mindful of contractual terms like this, where all they're saying is you're just going to get more time. You're not going to get any more money. And this is one of his slides with the clock there. Waiver of lien and bond rights is another key contractual term. You can waive your lien and bond rights by signing a contract, and you don't need it, independent consideration or anything like that. Here's an example. Again, I apologize for the fine print, but a lot of times these nasty provisions are hidden in the fine print somewhere, and you don't realize it until it's too late. And you got to kind of highlight the certain, piece it together. But the subcontractor agrees that no liens or claims, whether mechanics liens or attested account, will be filed or maintained against the project. All the other stuff is just kind of add-ons to build this thing up for parties. Just kind of more to muddle what's really what they're saying. And then the other term down there is the subcontractor is hereby expressly waive, release, and relinquish all rights to file or maintain such liens and claims. again, you want to know what you're signing, and you want to look at that and understand, because it's hard to pull all that out of a big thick paragraph like that. But if you sign one of those and you get in a situation where you need a mechanics lien, that's something that someone's going to come back and remind you about.
What does it use in terms of mechanics?
A mechanics lien? A mechanics lien is an ability for somebody that's incorporating work into a project, into a property, to be able to get a property interest in that property, kind of like somewhat like a mortgage. You can assert a mechanics lien in the amount of work that you put into that project. The thing about a mechanics lien is it allows you to assert a claim directly against the property owner. Whereas in a lot of situations, if you're a subcontractor, you're downstream, the only person that you can really assert a claim to or file a lawsuit with is somebody that you got a contract with. And more oftentimes than not, you don't have a contract with the owner. But a mechanics lien allows you to say, well, look, I provided all this work into this project. I didn't get paid for it. I'm going to assert this lien on this project. So if the owner ever wants to transfer that property, he's got to do something with that mechanics lien. And it allows you to kind of stay in the hunt to get paid. The mechanics lien can trigger a lot of different things. It can trigger the owner's agreement with the general contractor that the property was going to be lien free, and it can put you in a position where you're getting paid. I call it's kind of like aspirin for getting paid. If it's a minor problem and people are just dragging their feet and you assert a mechanics lien, a lot of times it helps people find their checkbook. But if it's a big problem where the owner doesn't have enough financing and the bank has taken over, is a mechanics lien going to come in and save the day? Maybe, maybe not. But it's relatively inexpensive to do, and it keeps you in the hunt. Thing about mechanics liens is a lot of times there's timing from your last day of work to be able to assert it. So if you're seeing that you're not getting paid on a project, you want to keep in mind what the applicable statute is in your state, so that you don't blow all that. Here's just some more language where in a contract where someone's trying to get someone else to waive their mechanics lien rights. There can also be obligations if you assert a lien or somebody below you asserts a lien that you've got to remove it. Again, this can be problematic if one of your suppliers isn't getting paid too. He's got a lien. He liens the project. A term like this could put you on the hook to have to do something about that lien. Be mindful of unconditional lien waivers before you receive payment. Sometimes, a lot of times when you're submitting pay applications, people will have you sign these before you actually receive the check. Well, I gotta have you sign this release that basically saying I'm getting this money and I acknowledge it, but you're really not. And people will say that to be able to claim that, well, I need that to be able to process your payment. And a lot of times you can see that where it's an unconditional lien waiver, the receipt of payment is hereby acknowledged. Basically what you're saying, if you're signing this, is you're saying, well, I've gotten paid this, and I'm releasing all my liens, even though you may not have gotten paid it. It may be a harmless paperwork thing where people are asking you to sign this before you get paid, but it can come back and haunt you if, on your last payment, your last pay application, and the thing gets muddled up because there's a whole bunch of claims, and you've signed one of these thinking that, well, I signed all the other ones before and I got paid on it. This can come back and haunt you. The solution to this is condition your lien waivers, any lien waivers on receipt of payment. To the extent I get paid, then I'll release my lien. But and you can submit that, and people shouldn't have a problem with it. If they issue you a check, we can go back and you cash the check. You can line it up with the payout with what they signed. You can follow it up with another unconditional one.
It seems like when, let's say, you didn't get paid and about to file a lien, today is the amount agreed upon? Is it, because I know it's one side, and the other side's not talking, so you go into the legal entity who's going to do the lien, and you just show your contract. I never got paid this $100,000. That's never a guarantee that the owner, in order to clear the title, has to pay that $100,000. There's got to be a secondary battle for what that amount really should be.
Sometimes there can be when there's disputed work. When there's disputed work items, it's a change order, things like that. A lot of times with material suppliers, more oftentimes than not, we're not arguing about the amount. But the short answer is it can vary. Material suppliers, if there's a mechanic's lien, there isn't a lot of haggling over the amounts. Subcontractors, when there's disputed change orders and things like that, there can be. This is a conditional waiver, which is something you should look for on progress payments. And you can see it just says condition upon payment of the sum. So when we receive this sum, we're going to release our liens, our lien rights to the extent we get paid that. It doesn't say which is hereby acknowledged, like the other one did. One of the other things that you want to be mindful of is when you're signing partial waivers for payment is if at one point in time the waiver is pretty short, right? In the middle of the project, it's pretty straightforward, and then all of a sudden it gets really long. Well, the reason why it's getting really long is they're asking you to waive something that you probably otherwise wouldn't know that you'd be waiving, for stand-up progress payment. Because a lot of times when people sign a progress payment waiver, my understanding, the way I always understood it was, well, I'm just releasing what you're paying me for. I'm not releasing anything else. Just to the extent you're paying me this, I'm releasing my ability to assert a lien or claim for that amount. In this release here that they put out on the project midway through, when they probably knew that the owner was going to be going under, they put this term in here. It says, in return for said payment, the undersigned hereby waives and releases any rights it has or may have to any and all types of claims relating to the project. So now, instead of it just being, hey, to the extent, you're paying me for this amount, I'm releasing, it's all claims related to the project. And nobody, that's a hard thing to see when you're doing these standard progress releases, and you're trying to get paid, and there's somebody in the you're not expecting everybody in the office to be able to look at these things like a lawyer would, but it's just something that we're seeing or we've seen to hopefully you don't learn the hard way. Additional insured. Additional insured is oftentimes thought of as broad form indemnity. Basically what additional insured means is your insurance carrier, what you're paying for, is going to insure someone else. And people are going to take that, use that coverage that you've paid for, oftentimes as another pocket. Consensus stock, one of the key differences about consensus stocks and AIA is how they address the additional insured. Consensus stocks, it has options that you can select. You don't have to select any additional insured. The AIA, though, mandates additional insured for the subcontractor. So that means if you're a subcontractor, you're signing an AIA document, you're going to have to have the architect, the contractor, his consultants, all listed as additional insured. If nothing goes wrong on the project, it's not going to be a problem. But if something goes wrong on the project, the owner is going to go to your carrier and say, "Hey, look, I'm listed as an additional insured. I'm going to use your insurance policy almost as if I bought it." And that can drag down. They can mess with your with the premiums that you're dealing with your deductibles and things like that. And that's probably that is a big difference between how consensus stocks and AIA work. Like I said, additional insured, it's your risk exposure. If something goes wrong, it's really a policy that somebody else can rely upon. So you just want to think about the exposure that you're undertaking. There are costs to it. Your policy limits can be reduced, and it becomes a part of your claims history when your insurance company is looking at your premiums.
Are you just talking about, like, when we do policies, we have to do additional insured all the time, but in the comments section, it's listed just for our work or our part of the project? Is that what you're talking about, for the part of the project that you do, or for anything that happens on that project?
It's limited to part of your project, right, your aspect of it, but a lot of times all they have to do is find out, well, you were tangentially involved with this thing that went wrong, and here's the policy, so, we're going to go after it. So what's triggered is what you're doing on the project, obviously, but a lot of times, if they can tangentially relate the problem to something that somehow you were involved with, you could say in whole or in part, you may have just been 1% involved with it. Your policy, that can all get triggered by that. The key with that is to say, look, if you're going to do additional insured, you're only going to do it to the extent it's a problem that you caused, to the extent that you did something wrong. It's not going to be something where if it's 99% somebody else and 1% you're on the hook for all of it. That's probably the key that you want to keep in mind. And this is kind of what I was just talking about with the consensus docs. You can, they've got these options to do the additional insured if that's in fact what the parties agree. If they do agree, then if there's an upcharge for that, that's something that the subcontractor can get a change order for. The other key here is to the extent caused by the negligent acts or omissions of the subcontractor. And that kind of goes back to what you were saying, is it confines it to something that you were doing wrong rather than just something that maybe you were just tangentially involved with, and as a way to limit your exposure there. The AIA, it requires a contractor, owner, architect, a bunch of different entities to be listed as an additional insured. They also have an additional insured for completed operations. So when the project is done, you also have additional insured obligations on that, and it's limited to the subcontractor's negligence. The best case scenario is to strike the additional insured. I understand though that's hard. If you do have to live with it, then you want to limit it to your own, to the extent that you're negligent, and then talk to your insurance broker is the other thing to keep in mind. Let them look at the terms and make sure that you have coverage for what the contractor is saying you have coverage for.
One thing I've seen is they'll ask for the price, and give them the price, and then they'll send you the contract to work. Suddenly they'll have additional insured, which if you go to your broker and say, okay, can you do this? And they say, well, yeah, 5% of the terms of the contract, whatever. Now it ends up costing you some money after you've had it. So that's a big negotiating point. Not that you ever want to sell your insurance to someone else, but if you're desperate, at least you don't want to get hit by your insurance company for an additional bill, and then you've already set a price to someone saying, this is what it costs.
Right.
It's your contract that you want me to sign. Ask for this additional insurance. It's going to be this much more.
And I'll get.
You always have that to bid. I mean,
Well, if you assume that they're going to do that.
We don't all our do. So we have that to our bid.
And that's the last slide I have in this presentation. But that's probably the most. If there's one thing you can take away from this presentation is to condition your bids on a suitable subcontract. And I'll show you language on that. Condition your bids on a consensus doc 750 so that you're in a position where if you do get the job and the numbers come in right and you get a big, thick subcontract that you don't want to sign, you can sit around and you can say, hey, look, my bid was conditioned on this consensus doc 750 or AI, whatever is your liking. Those are the terms. And if they change that, if they want to come back and change that, you have the ability to walk away and say, hey, you know what? I don't have to do this. My bid was based on that term, on those contractual terms. And that should be something, that should be just put on the end of every bid that goes out. And I guess if there's one thing that you can take away from this, hopefully you can take away that. But I'll show you the language at the end. How are we doing on time? I've got 15 minutes. The other point, I guess the other term you want to look at is how the change order terms are drafted. You want to be mindful of a subcontract that says that basically doesn't have anything in there about proceeding with work without written direction. In this climate, you want to be able to you want to be in a position to say, look, I'm happy to do this work. In the past, I'm an old school contractor. I do it by handshake, but your contract says I have to go by written direction. So I'm happy if you send me an email, you send me something that says, look, I want you to go ahead and proceed with this. I'm happy to do that. Or if you want to tell me not to pay attention to the subcontract anymore, I'm happy to do that too. You'll just put that in writing. But the last thing you want to do is be in a position where you're proceeding with work and you don't have cover in terms of an email, a field work order, or something like that. And you want to look for a subcontractor that basically has that so that you can be in a position where someone's asking you to do extra work, says, well, your subcontract says, I can't do extra work unless you direct me to. And we can agree that there's a dispute. You think it's something that's part of the subcontract. I don't. But you know what? We're going to at least have some paperwork back and forth on it where you're directing me to proceed. We'll keep track of it. But there's going to be no dispute about how about I'm expecting to get paid for this. You may not, but there's not going to be any surprises about somebody arguing about a bill at the end of this at the end of the project. The thing that we're seeing in Ohio is the notice provisions. If you see work out there that's a change, a lot of times you've got to be able to provide written notice that, hey, this is a change of the subcontract, and if you go ahead and proceed with it, then you're on the hook. And we're seeing some very nasty court cases where people are getting wrapped up in that. And it's not so much a case where the guy didn't provide the notice. He did provide the notice. He just didn't provide it within, like, the quote 10 days or 48 hours. So really nobody was hurt by the fact that maybe he provided on the 12th day. Everybody knew it was extra work. If they didn't want him to do it, they could have stopped him. But a judge looked at it and says, well, the contract says you got to provide it within 10 days. You provided it in 15. You admitted to it. So, thanks for doing the free work. And this is the terms that you'll see people try to trip up subcontractors. The contractor shall not proceed without any change in the work without appropriate written authorization. His failure to do that shall constitute a waiver by the contractor of any adjustment to the contract sum or contract time for the related work. So that's what will be used against you if somebody doesn't want to pay and you don't have the paperwork to back it up. As I indicated, it could be a simple email if somebody's dragging their feet. This is kind of an example one I thought of. Unless you indicate otherwise, we will proceed with the additional work as we were directed in the progress meeting. It always seems like there's always hemming and hawing in a progress meeting. Somebody wants it done, but somebody doesn't want to pay for it. Earlier today, and this email should serve as a continued notice of our intention to receive additional compensation for this change. At least in Ohio, that's the mindset of people. That's what the court rulings are telling people they have to do. It's not the way a lot of projects were built. It's not probably good for the industry that people are having to do that. But the last thing we want to do is have one of our clients, do free work when it's something that he was entitled to get compensation for just because he got tripped up on one of these notice provisions. This is hard to read, and this is another national contractor here, but I was talking about this 10-day time period to provide this written notice. In this one, it's 48 hours. Based on this subcontract, you're supposed to be able to provide written notice within 48 hours of when you think you're entitled to additional compensation. That's literally impossible to do on most construction projects because you don't know what you're dealing with. You know, a lot of times nobody wants to have to write these letters. Nobody wants to get in these situations. You only get in these situations when you really know what's going on, and by that point in time, somebody could say, well, you know what, you knew about this 2 months ago. You knew this could have been a problem, right? Right. Well, that's beyond 48 hours, and that's a real hard hurdle to get around. And people we're seeing it, unfortunately, at least in Ohio, use it against subcontractors and contractors. Once you get to a point where you do the extra work, you do all this paperwork, you get a change order. You want to be careful about what the change order says and what you're releasing with it. In general, the change order should include all the costs associated with that work. If I'm an owner and I'm issuing a change order, I don't want to have you come back and say, well, you know what, I want more money for that. I didn't add all that in. I want a one number that includes everything. And if that means that you were delayed by this change order, if there are some accelerations you have to do to finish the project based on this additional work, I want that in that change order. And that's a typical. I apologize here; it's hard to read, but that's a typical change order language where the compensation would include all delays, inefficiency costs, everything under the sun related to that change order. So if you're doing extra work for that change, it's going to include everything soups to nuts. So you can't, the owner's got protection on that, and then conversely, you're to include all the costs associated with that. So if the contract duration doesn't change, then you should include whatever it takes to get the contract done in that period of time. That's a typical change order, probably one that everybody in this room has signed. No one's really going to have any problems with. The ones you want to watch for is language that says something to the effect of, we're just not going to ask you to waive all the claims related to this work for this change order. We're going to ask you to waive all claims up to this point in time that you sign this change order. So you could be setting a door frame on a $10 million project, and you get a change order late in the project. You could sign a $500 door frame change order. And based on the language of that, you could be releasing all of the claims that you have on that project based on that change order. Here basically it says through the acceptance of this change order, the subcontractor recognizes that there's no basis for any such claim in the future. So you could have done all these notices, all of this written documentation, and then get tripped up by a change order that's got this real broad language. Here's another example of it. Through the acceptance of this change order, basically the contractor is acknowledging that he's got all the costs included in it. Like I said, the difference between the good kind of change order is that instead of through the acceptance date of the change order, it's just confined to the work itself. And if you're unsure that the change order it has all your delays and inefficiency costs, then obviously, you want to strike it out. But if you're signing a change order, you just want to be mindful that it's just confined to that change order, and that you're not going to have a chance to go back and get another bite at the apple if you find that the work, that you were delayed or had to accelerate. You can handwrite changes onto these change orders before you sign them, and it'd be amazing. But a simple note like that can change the value of a claim, and see in this project they confined it to this change order, and then he's got language down here. Where he's still carving out the cumulative impact of his prior delays and things like that. The other contractual term you want to think about is the dispute resolution, and by that you mean, well, where are you going to end up if there's a dispute? Do you end up in arbitration or litigation? Arbitration is brought before an arbitrator, somebody with construction experience. It's supposed to be faster and more efficient. I think there's a lot of people out there that don't have that same feeling. When it all comes down to it, a lot of people will tell you that the cost between litigation and arbitration are going to be pretty close. The one difference between arbitration and litigation is an arbitrator's decision is binding, it's final. Whereas with litigation, if you get a judgment from a judge or jury, you've got an appeal right. So that is one instance where the timing of that will drift on because of the appeals. And I kind of mentioned litigation already. Probably the one thing to keep in mind is in an arbitration, it's going to be decided by somebody that's got some construction experience, may have some experience in the specific field that you're working on, depending on the size of the claim. If it's in excess of $1 million or $5 million, it could be tried by a panel. On that panel, you could have a groundwater expert, you could have a construction attorney, and you could have somebody else. That may be something that benefits you in terms of that person making the decision versus a panel of juries or a judge that has never really dealt with this before. You can go around in circles and what's the best who's the best person to have decide your case. It used to be before 2007, if you're using an AIA contract, it was arbitration. But in 2007, now they've made it check the box. That's probably because there are so many people that are unhappy with the arbitration process and didn't really think that it was any better than litigation. So in this case, now people can choose for themselves what they want to do. And then it says if they don't select the method, then it goes to litigation. So litigation is the default. One thing to keep in mind with respect to the dispute resolution is where is it going to take place? If you're dealing with a national contract, a national contractor, a lot of times the location that's going to be in their contracts is going to where their home base is. So you could have to go to New York or somewhere far away from the project. In Ohio, terms like that says, hey, look, you build a project in Nevada, but you got to go to California to try it. That's not going to be enforceable, and that's the case in Ohio. You probably there's similar statutes probably around the country, but nonetheless, you want to keep that in mind when you're looking at where a dispute's going to be resolved. Because again, if you do have to fight a dispute, and if you got to fight it, out of state, that's just going to drive up the costs. And a lot of times, changing a contractual term like that isn't that big a deal on the front end, but on the back end, if you're dealing with it, it'll get pretty pricey. So litigation, as I indicated, in Ohio, you've kind of got a safety refuge that it'll take place in the state. Like I said, I presume you've probably got a similar type of statutes elsewhere. So you'll get the benefit of the doubt if you go ahead and sign a clause that says you got to go elsewhere to try it. With arbitration, that's not going to be the case. If you sign a contract that says, look, if there's a dispute, we're going to arbitrate it, which is fine in and of itself, but that arbitration is going to take place, in somewhere else in the state outside the project. You want to be mindful of that because that probably will be enforced. That can be enforced against you because of the way the Arbitration Act is written. It's a federal statute, and the federal statutes will trump what a state statute will say. So you want to keep that in mind. If you do select arbitration, you want to make sure that it takes place in the where the project is located, so that you don't have to travel. And I'm just about at my time. Indemnification is a proper duty to reimburse another for a loss. So basically, you're on the hook if something goes wrong, and they can at least say you're partially or you're somehow you're somehow involved with it. The indemnification clauses are really oftentimes really long, really hard to read. what you want to remember is, look, I'll indemnify someone for damages I caused by your own negligence. And indemnification should line up with whatever insurance policy you have, your CG&L. So whatever you're contractually agreeing to in terms of indemnification, you should have an insurance policy that's going to sync that up. And if you're not sure, before you sign a contract that's got a big, long indemnification provision, you want to send it to your insurance agent and have him take a look at it to make sure that the two match. Because, that's why you have insurance. If you screw something up, that's why you have insurance. You just want to make sure that you got a policy to rely on. What you do want to be careful of is this idea of this duty to defend. If there's indemnity provision, to the extent you're negligent, that's fine. That's why you have insurance. But if there's this defense requirement too in there, that's something you really want to be mindful of, because even if you're tangentially involved, you could have this duty to defend an owner or a general contractor through all of this dispute that he's got going on with the owner. Let me rephrase that. With that, in a typical indemnity provision, if you're negligent, you screw up, you got to pay. If there's a duty to defend requirement in there as well, let's say the ruling is that you weren't negligent, but you still had a duty to defend the general contractor against the owner, you're still going to be on the hook for the legal costs. So you could be in a situation where you could be like, look, I did nothing wrong here. I can prove it. Everyone knows it. But there's this duty to defend obligation. Someone say, like, well, you know what, you're right. But even if you are right, you're going to have to spend $100,000, or you're going to have to spend $100,000 in his legal costs to get there. So, and that's not something that's covered by your insurance carrier. So, with indemnity provisions, you see a duty to defend, you want to cross it out. The AIA has a good indemnity. It's limited to just indemnify for the extent that you're negligent. It's limited to bodily injury or property loss. These are things that you have insurance for. There's no duty to defend. It's limited to the extent you're negligent. And it's just limited to bodily injury and property loss.
The owner is given specs on what to do the job by. Prime contractor did their work. Subcontractors in on it now. And the problem is that they did it by the specs given by the owner, and the specs got them in trouble. But here it says hold harmless the owner. The owner at this point has given the contractor the option to just walk off and leave the contract. Where does that leave a subcontractor? If he holds harmless the owner.
In your case, if there's no contract with if the owner doesn't have a subcontract with the subcontractor, if there's no subcontract between the two, the owner can't go around, and in most cases, in most states, the owner can't go around and seek a claim against the subcontractor.
Okay.
Now, what he can do, though, is let's say that kind of triggers this additional insured. If he's got an additional insured, he may be able to get it through that route.
But the subcontractor wants to go ahead with the job. The contractor at this point has the option to just say, I quit and go home with nothing attached. So what's the option of the subcontractor?
Well, a lot of times, like in these subcontracts, there can be an assignment provision where they can assign the subcontract between the sub and the general to the owner. You do something like that. Is that am I answering your question, or?
I don't know, but it says hold harmless the owner. So the subcontractor can't go to the owner and
Right. Well, okay. Yeah. What triggers this is bodily injury or property loss. Okay. So there's damage to the property. If it's just if there's just a contractual dispute where he doesn't do it in time or somebody's got a fight over extra cost, this doesn't come into play. This comes into play when there's an accident on the project, there's a defective work or things like that. But that's a good point because it's limited to bodily injury and property loss. Sometimes you can see these indemnity provisions much, much broader than that.
Yeah, in this case, it's arguing over change order.
Right.
The prime contractor says, hey, he has the option to just say quit and leaves the subcontractor just hanging.
Right. And this is kind of a real nasty one. It says the subcontractor from and against any claims, penalties, fines, judgments. So not just issues related to bodily injury or property damage, which if we're dealing with this term, then people are in trouble. You know, people got problems. With, right. Now, in Ohio, you can't indemnify somebody for their own negligence. Okay? So if they screw up, you can't indemnify them for that. So, like a term like this and a fact pattern that you're just telling me about, it all may not be lost there. You know, I can't be an owner and screw something up and then have you pay, you know, and expect you to pay for it. So it's not as bad. But this is a real long indemnity provision. It's got to indemnify and defend, and it's beyond bodily injury and property loss. You know, claims for non-payment, so on and so forth. So you know, this can come back and haunt you. Safety violations, in terms of if you're indemnifying somebody for a safety violation that's caused by you, that's fine, but you want to limit it if there's a repeat violation or something like that against this general contractor that you don't get stuck with. So if he has 10 violations from OSHA and you hit the 11th and there's a big long claim because of something that you triggered at least initially, you don't want to be on the hook for his other 10 violations. Incorporation and flow-down clauses, you just want to be mindful of having a good handle on all the documents that are included in the subcontract. You want to take a look at them. You want to have them in your possession. Consensus docs requires the contractor to give them to you. A lot of times, you're signing agreements that you don't have all the pieces and parts to. And if there's a big, long dispute, people pull these clauses out that you never saw, that probably only 2 people have ever seen, and now you're haggling over it. A flow-down provision, basically, whatever obligations the general contractor has with the owner, those should flow down to you, and vice versa. If the general contractor's got some rights against the owner, you should have the same rights against the general contractor. What's good for the goose is good for the gander. And this is an example of what we were talking about earlier, the right to project financial information. The AIA documents have it as a condition precedent. That's a right that the contractor has against the owner. If you got a flow-down provision where it's working both ways, and you're a subcontractor, hey, I can use that too, and you can use that term against the contractor, saying, hey, look, you got that term against the owner, I have it against you, so let's get the financial information out there. You want the obligations to flow both ways, not just one way. Not a situation where the general contractor just can assert on you whatever bad things the owner can assert on them. And this is an example of a one-sided one. integration. This is kind of the last point I want to bring up. Basically, what an integration clause does is say, look, whatever prior negotiations we had going on with each other, whatever talks you said was in your number, wasn't in your number, that's all fine and dandy. But we've got this integration clause that basically says the four corners of the subcontract are going to govern. So whatever conversations we had don't really matter. And where that can be problematic is if you're submitting a quote and you say, look, I only have these certain things. I'm not doing it. I know the specs say I'm supposed to provide X, Y, Z, but I can't get X, Y, Z, and my quote is based on something different. If you go ahead and sign a subcontract that has this integration clause in it, despite the fact that everybody knew what your number had, you can be on the hook to provide whatever was in the spec for X, Y, Z. And that could be, a lot of times you see that with scope items where people will sign something and they have everything included in the spec, but then they'll come back and say, that wasn't what we talked about, and you see this integration clause come back and bite people. This agreement constitutes the entire agreement between the parties. No oral representations or other agreements have been made by so-and-so except as stated in this agreement. So that agreement is going to control. If it's in that agreement, then you've got it. If you don't, then you're in trouble. Why can this be a problem? Like I said, it can nullify a properly qualified bid. The way to get around that is you want to have why can this be a problem? Because the signed agreement is going to control. It's going to supersede all your prior negotiations, including quotes. And the last slide I mentioned earlier is when you submit a bid. When I say private bids, not something in a public context where you can't always condition it. But when you're submitting a bid, you want to say this bid is conditioned upon the use of consensus doc 750 form agreement or whatever AIA agreement. You just have that just at the bottom of every bid that you put out there. That way you're in a position where if somebody says, hey, look, you got the job, here's the subcontract, you can be in a position to say, I can walk away from this subcontract and I'm not obligated to honor I'm not obligated to sign your subcontract because you're changing the terms of the deal. If you don't put that in there, you can run the risk of saying, hey, look, I relied on your number, I submitted it to the owner, and now you're walking away from it, and you're going to be on the, we're going to be at a battle on, if I got to pay extra to get somebody else out there to do this. This just puts you in a very good negotiating position, and it allows you to get the best terms if you do end up trying to negotiate your work. So I'm running a little over, apologize, but I'll stick around, and if you guys got any questions.